Okay, this is WMU Political Science 325, and it is distance learning number 6. This will be April 1st, 2020 on your syllabus, the disclosure and preservation of evidence. This will be chapter 9, section 9.12, so please read that in the book. It's just a few pages. This particular lecture won't take too long. I generally use this lecture on the heels of going over the examination, so the lecture itself is not too long. And in one of the subsequent lectures, we'll do a little review of the examination, which you took earlier in the week. So let's get right into it. There is an obligation on the part of the government that is not written in specifically into the Constitution that says that the government has an obligation to disclose evidence to the other side. So let's break it down. What are we talking about? The obligation on the part of the government is to provide to the opposing side that evidence which is in the possession of the government that is favorable to the defendant and is material on the issue of his guilt or punishment. In other words, if I'm the government, I'm law enforcement, and I have evidence that is favorable to the opposing side and is material on the issue of that individual's guilt or the likely punishment, I have to provide it prior to trial to the defense. One of the things that we need to understand about this adversarial process when we talk about criminal justice is that it's the responsibility of the government. The prosecutor's responsibility is not specifically to do victory, but to do justice. It is fundamentally unfair to the accused to not have this information in preparation of trial. Most government agencies have at their disposal hundreds, if not thousands and thousands of dollars in individuals in order to prepare a case for trial. And oftentimes an accused is alone, that is, them and their attorney, and not vast resources. Although the government has an incredible burden that is beyond a reasonable doubt that they have to establish, the Supreme Court has ruled that it is fundamentally unfair to an accused not to have the government provide information that is both favorable to the defendant and is material on the issue of their guilt or subsequent punishment. The landmark case that talks about this is known as Brady versus Maryland, which is at page 473 of your book. What happened in Brady was that the government had in their possession a confession to a crime by somebody other than the accused, and the government failed to provide to the accused the other individual's confession. In other words, Mr. Brady is accused of a crime, he's being prosecuted, and the government has from some other individual their admission that they committed the crime that the government is charging Mr. Brady with. Ultimately, this comes out after the matter is resolved, and the Supreme Court ruled that the government is not permitted to suppress, that is, to withhold evidence that is both favorable to an accused, where that evidence is material either to guilt or punishment. And as a result, Mr. Brady's conviction was overturned. Failure to provide the defense with information that could change the outcome of the trial compromises the integrity of the verdict. In other words, in Mr. Brady's situation, had he been provided a confession to the crime he was being charged with from the government, then the defendant could have used that possibly at trial, and his outcome may very well have been different. And so Brady is that first major case that tells the government that when they have this information, they got to turn it over. So what type of evidence is it that we want to make sure that we understand has to be disclosed? What type of information? Obviously, somebody else's confession to a crime is something that needs to be turned over. If the government is granting immunity to any of the witnesses that they intend on calling at trial, that's the type of information as well that the defense has the right to have in their possession. Evidence that bears on a witness's credibility. That is, if the government is going to use an informant and they have information about the informant that suggests that the informant may not be credible, they have to disclose that as well. What about lab analysis? For example, a DNA test or a ballistics report. If the DNA test comes back and it shows a negative result, or a ballistics report comes back and it shows that the gun that they put in the defendant's hand is not the gun that was used in the crime, then those are the types of things as well that need to be turned over to the defense. So, negative results, if you will, from a police investigation have to be turned over. Some of the things that don't have to be turned over are the government's notes or work product. If the government sits down with a witness and the government's opinion of the witness is that maybe they're not a very good witness, that they may struggle during a trial, the fact that the government has formed such an opinion like that is not something that they have to turn over to the defense. The evaluation and observation of prospective jurors. So, for example, during the voir dire process, if the government hire somebody to evaluate who might be a good juror for this case, that's not the type of information that needs to be turned over to the defense. The rationale being that the defense can find that information on their own. They have the ability to do the same thing that the government is doing. And so therefore, the government is not obligated in preparing their work product for a case to turn that over. So, any evidence that's known to the government that is indicative of favorable to the defendant and material on the issue of guilt or punishment has to be disclosed. And that's what Brady says. Now, what about evidence that maybe the prosecutor is not aware of? What if the police have evidence and they don't give it to the prosecutor, and therefore the prosecutor doesn't give it to the defendant? What about that? And that situation was addressed in a case called Kyles, that's Kyles versus Whitley, at page 743 in your book. What happened in Kyles versus Whitley is that the prosecuting official who was trying the case showed the jury a blurry photo of cars in a parking lot. And the prosecutor did not tell the defendant that the police had taken down all the license plates of the cars, and the defendant's car was not one of those that was found in the parking lot. In other words, the prosecutor shows a blurry photo of cars in the parking lot and intimates to the jury that the defendant's car is one of these cars. The prosecutor never told the defendant that the police had taken down all the license plate numbers and found out that the defendant's car was not one of them. However, the police never told the prosecutor of this action, and therefore the prosecutor then never told the defendant because the prosecutor was not aware. And so the government argued at the Supreme Court level that if I, as the prosecutor, don't know of it, how can I reveal it? The Supreme Court ruled that the prosecuting agency has a duty to find out if law enforcement, that is the police, possess any of this Brady-type material. And the knowledge of this is imputed to the prosecuting official. And if the police fail to reveal it, then the prosecuting attorney is the one who will suffer. So it is not only information that the prosecutor knows that exists, but information that is favorable to the defendant on the issue of his guilt or punishment. But any of those agencies that are working on behalf of the prosecuting official, that is law enforcement or maybe some other testing agency or what have you. So the government has this high burden to prove beyond a reasonable doubt, but they also have an obligation to hand over to the defense that which is both favorable to the defendant, that is favorable to the defendant and on the issue of guilt or punishment. The next topic is the issue of preservation of evidence. Does the government have an obligation to preserve evidence that they have obtained in order to maybe disclose it at a later time, or at least give the defense an opportunity to review it? And the government does have this obligation. Again, this goes to the idea of fundamental fairness. If the government has, through their means, through subpoenas or other court orders, has obtained information that may be used against a defendant, in certain circumstances, the government has an obligation to preserve that evidence. And there's a couple of cases that talk about it. That is California versus Trombetta, which is at page 475, and Arizona versus Youngblood, which is at page 745. The sum total of these two cases describe the type of evidence that needs to be preserved. And there's three requirements, ultimately, when we get through the Youngblood case, that have to exist in order for a defendant to show that the government was obligated to preserve it and then failed to preserve it. So let's look at the two cases. Trombetta, again at page 475, was a case where the government obtained a breath sample from the accused in a drunk driving type case. And in that particular case, the state of California found Mr. Trombetta to have been operating a motor vehicle. They believed he was under the influence, so they took him down to the police station and he gave a breath sample on a machine. Ultimately, that sample then was purged out of the machine. The actual alcohol and breath was purged. That it means it was thrown away. And the only thing that remained was some computer-generated result of what that sample was. So we have a result that reflected, presumably, that he had beyond a legal limit to operate a motor vehicle, but you don't actually have the breath sample any longer. It's been tossed away. So ultimately, Mr. Trombetta argued to the Supreme Court that the government never preserved that sample. Once he blew into the machine and they purged it, he never had an opportunity to get that sample to do his own testing, for example, to show that it wasn't above the legal limit. So the Supreme Court ruled that the government is obligated to preserve evidence when two things are met. And again, as I mentioned a moment ago, there's now three requirements. But at the time, with Trombetta, there were two things. The first is that the sample, whatever it is, has apparent exculpatory value before it's destroyed. That is, it has value that would help the defendant, that would exculpate him, that would demonstrate that he's not responsible. So if the evidence has apparent exculpatory value before it's destroyed, and secondly, is the type of evidence that the defendant would be unable to obtain by using other means. That is, similar evidence would not be able to be obtained by using some other means. The Supreme Court in Trombetta ruled that those are the two requirements that the government was obligated to uphold. That is, if it has apparent exculpatory value before it's destroyed, and if the defendant can't get access to similar type of evidence or comparable evidence using other means, then the government has an obligation to preserve it. And if they don't preserve it, then it's a problem for the government. The Supreme Court ruled that breath samples don't meet these criteria. And the reason why they don't meet the criteria, because the result was positive for alcohol, and therefore it's not one of those things that shows it has apparent exculpatory value. And more importantly, the defendant could have gone ahead and hired an expert to challenge the test results, as well as go get their own sample after the government obtained the one that they wanted. In other words, after he gave a breath sample, the defendant would have been afforded an opportunity to go some other location to preserve his sample of breath and have it tested using his own individual. So because the Supreme Court ruled in that case that it was not required to, the government was not required to preserve evidence, that's why in drunk driving cases, if a person uses a breath machine, the machine then purges the results. The government doesn't have to keep them, so long as the government provides an accused an opportunity to go ahead and get their own sample. And in Michigan, that is a requirement of the law. That is, once the government takes your breath sample, it says to the defendant, if you want a breath sample as well, or a urine sample, whatever, you tell me where you want to go, we'll take you there, and you can get your own sample shortly after the government gets theirs. So it's not a requirement in a drunk driving case to preserve that breath sample for these reasons. So that's Trombetta. They gave us the first two requirements: has apparent exculpatory value before it's destroyed, and it's the type of evidence that the defendant would be unable to obtain, at least comparable evidence, using some other means. Then we turn to the case of Arizona versus Youngblood, which is at page 745 in your book. So what happens in this particular case? Well, the government is investigating a child sexual assault case. There was a victim of a sexual assault, and inside the victim, there was obtained a semen sample. That semen sample then was placed in a refrigerator, and then the government began their investigation trying to find out who the source of that semen sample in this child was. What happened is that the sample itself, placed in a refrigerator, ultimately was not preserved, and that the refrigerator either went bad, it broke down. In any event, the semen sample decayed, that it was no longer available to be used because you couldn't test it to determine any DNA or any other type of factor to focus in on who the originator of the semen was. So ultimately, Mr. Youngblood gets arrested. He was the focus of the investigation, but at the time that the semen had been obtained from the child, he had not been charged. And he argued that his rights were violated because the semen sample had not been preserved and it had met the Trombetta two-part test. That is, here's Mr. Youngblood. He's claiming that the semen sample had apparent exculpatory value before it's destroyed. His argument being, if you had preserved the evidence, it would have shown that it was not my semen. But since you didn't preserve the evidence, I can't demonstrate that. And the second thing is, he showed that it was the type of evidence that he was unable to obtain comparable evidence using other means. There was no other semen sample obtained from the child. So Mr. Youngblood argues, I got no other way to demonstrate that the semen taken from the young victim was not mine. So he argues that he had met the two-part test under Trombetta, and therefore the charges against him should not proceed because the government failed to preserve the evidence. The Supreme Court came in and said it is not a constitutional violation because it is not clear that the evidence would have been useful to the defense. The defendant had made the argument, but it wasn't that clear. But more importantly, Youngblood added a third requirement in order for a defendant to effectively argue that the government had failed to preserve evidence. And that is, the defendant must demonstrate that the government was aware of its exculpatory value and destroyed it in bad faith. That is, they didn't just carelessly allow it to be destroyed, like what happened in the Youngblood case, but they destroyed it in bad faith. If the government behaved negligently or carelessly in handling evidence, that's not sufficient enough such that the defendant would get a remedy. There must be a conscious intent to suppress. That is, a conscious decision on the part of the government to not give this to the defendant. And in Youngblood, the Supreme Court ruled that since that third requirement had not been established, then the case against Mr. Youngblood could proceed. The sum result of the discussion we want to have regarding preservation of evidence is that the government has an obligation to preserve evidence against the defendant when those three requirements have been met. Has apparent exculpatory value before it's destroyed. Exculpatory, again, meaning favorable to the accused. Is the type of evidence that the defendant would be unable to obtain either comparable or the same evidence using some other means. And the government must be aware of its exculpatory value to the accused and have destroyed it in bad faith. If you can't establish all three of those things, then you are not able to establish that the government has failed to comply with the preservation of evidence requirement. So those are the two topics that we want to make sure you're clear on: the disclosure of evidence, Brady and the Kyles case, and the language that's in the book, and preservation of evidence, that is the Trombetta and Youngblood case. that'll wrap it up for distance learning number 6, about 20 minutes worth. And we'll pick up next week with the last 2 weeks. That is 4 more sessions. Thank you.